Okay. Yes, we do have some handouts, and we can.
Oh, okay.
I'll pass those out here in a minute. We'll go ahead and get started. The handouts are for the ABLE Act at the end. So for those of you who don't know me, I'm Tracy Brewer. I'm the director of DSAC, and we started having monthly, we call them our coffee chats, just because I wanted to keep it informal. This is one of our larger groups, so it looks more formal, but I'm really not into formal, so, you know. But we are recording this, so we'll have it up on our website because there's a lot of information, and so if you're like me, I have to watch it several times and take notes and things. But we're so happy to have Karen Perch with us today. Karen has been a longtime supporter of DSAC. Gosh, Karen, I don't even know how many walks she's been to.
I don't either.
And she signed up again this year, too. So, but Karen actually helped Keith and I personally. We have 5 children, and Emily is our 18-year-old former Down syndrome. So I got to know Karen through Carolyn Wheeler, who did our insurance policy, and she was, you know, Emily was young, and Carolyn was like, oh, you've got to get all this structured right, and it was during that time that we were just so overwhelmed with medical issues and things like that. But I'm so thankful that Carolyn did that, because that did lead us to Karen, and you know, Karen was just great walking us through the process, and you know, we were able to just kind of hash some things out and made us really, really think about how do we want to structure that. And it's not a pleasant thing to think about. It's a hard thing to think about, but it's something that has to be thought about. You know, there's just some things in life that need to be dealt with, and this is something that you can't let slip through the cracks, because it's just too important. If you're doing all this work now and something were to happen, you know, what would happen to your loved one? So I realize it's a difficult subject, but it's a necessary subject, so we're glad that you are here. Karen, I'm going to let you, because I always mess it up, so I just let our speakers introduce themselves, and I find that that's much better than me trying to remember everything. So take it away.
All right. I am Karen Perch. I'm an attorney with a private practice in Lexington. I also serve as executive director for a nonprofit organization called Life Plan of Kentucky, which operates a pooled special needs trust. We'll talk about that a little bit later as we get into the presentation and the alternatives for trusts. And most of you don't know me or anything about me. A few faces are familiar. But because you don't, I'm going to just tell you a little bit, if you'll bear with me, about how I ended up in the special needs planning area. I am the oldest of 10 children. My youngest sister, Natalie, is our special needs child. She does not have Down syndrome, but she was born with seizure disorder, intellectual disabilities, has since developed some other things in addition. And when she aged out of high school, she lived in Massachusetts. We were already here at that point. She and my parents came visiting us one summer, and Natalie, out of the clear blue sky, said, Karen, I've never lived with you as an adult. Can I come live with you for a year? And my husband, saint that he is, said, sure. And Natalie didn't stay for 1 year. Natalie stayed for 11 years. It never felt like 11 years to me, and I would not trade those 11 years for anything. Every one of them was a blessing to our family for a variety of reasons. Just to give you one very simple example, Natalie would notice the humor in things that would go right past me or right past my husband. She would see it, and we would pay attention then to what she was finding funny. And sure enough, it was funny. And, you know, things like that we will treasure forever. Natalie is now back in Massachusetts. She's sort of rotating among the siblings. and adding blessings to their lives as well over the years. During the time that she was with us was also, we had little kids. I was just starting law school, and my parents had applied, my mom, my dad never did any of that stuff. My mom had applied for, sorry guys, that's the way it was in our house. Mom did it if it needed to be done. Dad was a great breadwinner, but Mom did the other stuff. Mom had applied for SSI for Natalie and was denied at the first level. And then she said, well, it's the government. They must know what they're doing. And she didn't appeal it. She just stopped. And that was very much the wrong thing to do. But by the time Natalie got to us, it was too late to appeal. So we had to start from the beginning again. We were new to Kentucky, had no idea what resources there were, if there were any at the time, no idea where to begin. So with kids and law school and Natalie, I was trying to figure this out, and I realized, okay, I'm a relatively intelligent person. If this is that difficult for me to figure out, it's difficult for everybody to figure out. And so it's really because of those experiences with Natalie that I do what I do now, and I've been doing it for more than 20 years, thanks to Natalie. Every now and then she asks for a head count. She wants to know how many people she's helped now. I can't tell her the truth anymore. I just make up numbers. And as long as it's a number bigger than whatever I told her last time, she's happy. So Natalie is responsible for what you're going to hear today, and hopefully you'll find some of it helpful. Contrary to what my title slide says, I am not intending to actually speak as part of the presentation about guardianship. I didn't even look at my title page. I keep a body of slides and I regroup them for different presentations. I never paid attention to the title slide. So you have the wrong title slide. We are talking about supplemental needs trusts, special needs trusts, and the ABLE Act, because there have been lots and lots of questions about the ABLE Act and how that works and how it compares. So I want to make sure that you have information so that whatever your circumstances, you at least know some of the questions to ask and can start sorting it out. Okay, so starting with the trusts, we're going to work from trusts to ABLE, okay? And if I can figure out how to work this. For most of your people with special needs, Medicaid is really a lifeline for many purposes. It provides medical care, doctors, hospitals, prescriptions, durable medical supplies. Some of that has changed in how it happens over the recent years with the Affordable Care Act. Durable medical equipment, dental services, and also, more importantly for many of you, helps with long-term supports through our Medicaid waiver programs. All states have some form of our home and community-based waiver. Kentucky specifically has 2 acquired brain injury waivers, one that's more short-term, one that's more long-term. Supports for community living waiver, and Kentucky is the only state that has any form of Michelle P. waiver. Do you all know how Michelle P. came about? Do any of you know how Michelle P. came about?
Somebody sued.
Yes. Michelle Phillips was on the waiting list for the Supports for Community Living waiver. And at the time, believe it or not, the waiting list was approximately twice what it is now. And her grandfather sued in U.S. District Court for the Eastern District of Kentucky, alleging that that waiting list was so long that it functionally was a deprivation of her constitutional rights because it discriminated against some people with disabilities. It did not treat all people equally. And they ended up settling it by the state agreeing to create a new waiver. And so the new waiver that was created was Michelle P. in her honor. It provides very similar things to what the Supports for Community Living waiver provides, except that it does not include residential services. It does, both waivers have, they shouldn't use community living supports and supports for community living, but both of them have options for community living supports and other kinds of services, but only the SEL has actually got residential services. Okay, so that's the basis, and most people, when they're looking into whether or not and how to do a trust, they need to protect either the medical eligibility, Medicaid's payment for actual medical expenses. I have more than one client whose medical expenses are over $100,000 a year. No one can self-insure for $100,000 a year. At least no one I know can. There may be some people. And many, many, many people, high proportion, are also trying to protect eligibility for those Medicaid waiver services, because regardless of which waiver service you use or your loved one needs, it's a substitute for long-term care in an institution that allows the person to remain in the community. So when you're looking into special needs planning and doing special needs trusts, you're figuring out, what can I do to make sure that person does not lose eligibility for those services? All right. In order to, I'm just going to put both of these up at the same time. In order to maintain traditional Medicaid eligibility for services, and some clients still need to be on traditional Medicaid services despite the Affordable Care Act, we have to worry about keeping the individuals countable in resources below $2,000 per month. And technically they can check any day of the month, but as a practical matter, they really don't. So if you make sure that the individual's countable resources are below $2,000 on any given month, or in the first day of any given month, then you're going to be okay. An eligible couple, sometimes we're talking about a husband and wife, and for example, I have clients at Cedar Lake in Louisville. Are any of you familiar with Cedar Lake? They actually, not too long ago, had their first wedding for 2 residents at Cedar Lake. And so, as an eligible couple, to protect their eligibility for resources, they would have to keep theirs below $3,000. Not everything counts as a resource, however. Some of the most common things that do not count when we're talking about planning and protecting eligibility for Medicaid services are the person's household goods, personal effects. Medicaid doesn't care about those anymore. There was a time when they did, but it's been quite a few years now since we've had to worry about that. Medical devices, adaptive equipment, they don't care about those for eligibility purposes either. Term life insurance policies also do not count. Cash value life insurance policies don't count if they are owned by someone else. For example, a parent owning the policy on the child's life. The child may be the insured person, but the parent owns the policy, and it may be used for burial expenses, for example, for the child. The home in which the beneficiary lives. And in Kentucky, right now, the limit on the value of a home can be as high as $525,000 that's a really nice home. That's a couple of times the value of my house. So sometimes people plan by actually spending up, buying up instead of buying down in terms of a home if they've got excess resources. At least one automobile per household is excluded. And if we're talking about a minor child, it'll be the parents' vehicles that they're looking at. If we're talking about an adult child, it's the adult child's household. Burial funds, burial spaces, life insurance assigned to a funeral provider as long as we don't go over the maximum limits in those. And people get confused about this because you can exclude up to $10,000 without getting separate permission for prepaid burial expenses, funeral expenses. Or you can have a savings account that's irrevocably set aside.
I'm sorry, the screen is not sharing with the webinar, so I'm just trying to get that to do that.
Well, I won't keep going past them.
Okay.
Is it working?
I'm so sorry, but nobody can see.
Okay? Yeah. All right. There's a second rule about funeral and burial expenses, and that is that you can have a savings account, for example, or a certificate of deposit that is set aside, earmarked for burial expenses, but if you do it that way, it's limited to $1,500. You're not going to do much for $1,500. So for some people, they're better off figuring out a way to actually prepay the funeral and burial expenses. Property essential to self-support. Some young adults, and it wouldn't surprise me if a lot of your young adult children might be able to work and eventually be able to support themselves fairly well. And if that's the case, if they need specialized equipment that is necessary to help them do that, that doesn't count as a resource either, but it does have to have separate approval. Do you need me to stop those? No, that's all right. Let me get the coffee out of your way.
Sorry.
You're fine.
It's
disappearing?
Yeah. So our folks on the webinar can't see anything that Karen's talking about.
Am I going from slide to slide in
No,
that
you're
way?
fine. You're fine.
Okay.
It's the
So these exclusions are because of to qualify for Medicaid or SSI?
If you qualify for Medicaid, you qualify for SSI and the reverse, but they don't have exactly the same rules. Are you running into a situation?
Yeah, I mean, my son's 12, and
He can medically qualify.
yeah, but they're taking it away this month, along with this Michelle C. waiver. And I called them, and they said, yeah, it ends at the end of this month, but the glitch in the system, because this computer thinks there's a better program out there, but we don't know the exact one. So I'm not sure what, but they're asking for our income and all that, and I thought that didn't. We're having the same issue.
Yeah.
Same thing. So.
A lot of people are. Yeah, a lot of people are.
You're fine. You're fine.
I'm fine?
Yeah,
We'll
I've got
come
it
back
figured
at the
out.
end.
It's all good. It's all good. I won't interrupt anymore. And we are going to, and we might have to talk about a couple things afterwards, but, and I know that was my fault, but, well, we might need to answer questions. And there are a lot of things like that going on with individuals because of identifying and computer glitches. Do you have any knowledge of that too?
I have had many calls for issues like that. And typically what's been happening, not consistently, but more often than I would normally expect, so it really may be a computer glitch, is we'll request a hearing, we'll request a reconsideration, whatever needs to happen, and then all of a sudden they'll get a letter saying it's fixed.
Yeah.
So it really might be a computer glitch, but it doesn't help you if you don't have services while they're trying to fix it.
Well, the lady that I talked to said she sent it to the help desk, but you should see the help desk. So she goes to call every week.
Yeah. The state of Kentucky switched their computer system for Medicaid services, and of course, for families on waiver services and things like that, it was not correct. So my understanding of talking with Frankfurt is that they have actually had to hire hundreds of people to come in to catch up the backlog of cases that have been kicked out.
Yeah.
So but I also have a name of the person that's in charge of that, Tammy or anybody else, that you can contact her instead of just the help desk.
Oh.
They told me as of last month, I've not experienced it personally, but I've just been trying to keep up with it, that they are catching up, but you know, I would still make a personal phone call to the lady in charge.
She said just call.
Yeah. But, all right, Karen, I think we're on track, and I won't bother you anymore.
And the final exclusion on this particular slide that we've been looking at are any assets, whether it's cash, whether it's investments, whether it's real property, anything that is held by either a supplemental or special needs trust. Those are all excluded when considering eligibility for services and benefits, as long as the trust is properly drafted and properly implemented. Both of those are important components. And we'll talk about the difference between those two terms in just a few minutes. All right, and I'm going to bring up this whole slide as well. Where do excess resources come from? Back payments from Social Security is a very common source of excess resources for people with disabilities. Being the beneficiary, named beneficiary of a life insurance policy. How many of you have life insurance policies and maybe you name your spouse first and your children are contingent beneficiaries? If your spouse dies before you, the proceeds of that life insurance policy becomes an excess resource, if you haven't done anything about it, for the child with the disability. But you could have some form of supplemental needs trust that is paid to for your loved one with the disability, Down syndrome or whatever else it might be, and it won't count as a resource because it doesn't ever actually belong to the person now or later. It just gets right from the insurance company into the trust that you established for benefit of that person. And accidental inheritance. I say inheritance. Sometimes it's intentional the same way. I leave everything to my children, and then a child dies before you who has a child with a disability. That's an accidental inheritance. Sometimes it's an intentional inheritance. And sometimes people don't have excess resources. They have a different problem. They think they need to disinherit their loved one with a disability, and no, you do not. There are ways that you can safely provide for your loved one with a disability through your estate without causing loss of eligibility for benefits. Okay, personal injury settlements is another common source of excess resources, sometimes as a result of an accident, sometimes medical malpractice. Big buckets of money sometimes suddenly appear that actually belong to the loved one. Another possible source of excess resources is child support. Child support belongs to the individual with the disability, And so it's countable as income in the month it's received, and if it's not all spent, it's countable as resources in the following months. So there are ways to protect for that as well, and some of you may need to know about that. And when we get to the comparison that we're doing among the options, first-party trust, third-party trust, and supplemental needs trust, and ABLE accounts, we'll talk about that a little bit more. Repayment of patient liability. This one has been a big one in Kentucky in the last couple of years because for quite some time, Kentucky Medicaid was charging adults with disabilities who had gone from being SSI recipients, supplemental security income recipients, which is the needs-based, means-tested source of income for adults who are poor with disabilities, to becoming what we used to call disabled adult child, and we now call childhood disability beneficiaries, which means that they're receiving income on the basis of a parent's work record, okay? When that happens, Medicaid is not supposed to treat you any differently for eligibility purposes. But what Medicaid had been doing in Kentucky for many years was treating those people as if they had never been on SSI. And so they were charging them a share of patient liability for services under the waiver program that was illegal for them to charge. And so there was a lawsuit which again got settled, and Medicaid has now been, please at the end, thanks, it's all right. Medicaid has been repaying the care providers, who in turn then repay the clients who were charged excess fees, and all of it, people are getting thousands of dollars in some circumstances depending on how many months those excess payments were collected. The largest one I've seen so far was $47,000, but this, I know, the smallest one I've seen was like $3,000 or $4,000, so that person must have only started being overcharged towards the end of the situation before it got settled. So, you know, those are things that are going on both nationwide and with respect to the patient liability repayments. That's Kentucky specific because Kentucky was doing it. What is a trust? A trust is a separate legal entity that's regulated both by the state, and the trust itself is regulated primarily by state law. And I just want you to think about it as a box or a cup or a holding tank, a bowl, I don't care, but just visualize it as something that's capable of having things poured into it, okay? Sometimes I compare it to a coffee cup, and it's there, waiting to receive whatever someone might want to put into it at some point. A trust is not something, and particularly a special or supplemental needs trust, is not something that you should try to draft yourself. It needs to have very, very specific language in it. And I would also caution you that, I'm going to give you an example. If you need heart surgery, you don't go to your general practice doctor for the heart surgery. You don't even go to the cardiologist for the surgery. So similarly, if you're talking about special needs planning, you don't have to come to me, but please don't go to a general practice attorney. Don't go to an estate planning attorney who doesn't have very specific experience in the area of special needs planning, okay? Make sure that you ask those questions. Don't be the guinea pig for the person doing their first one, okay? And And I know everybody's got a first, but my first was my sister's. So if I messed it up, I had to fix it. The trust can own virtually any type of asset that any individual can own. And it doesn't matter whether we're talking about a special needs trust or a supplemental needs trust. The trust can be both the owner and the beneficiary of life insurance. If properly drafted, it can also be the owner and beneficiary. It cannot be the owner of life insurance, of retirement accounts. It can be the beneficiary of retirement accounts. It can be the owner and beneficiary of personal property that's held by the trust. Those are important things as you're doing your planning. Each person, each family situation is somewhat different, so your trusts, when you have them, should not look like cookie cutters. They should be individually tailored to you and your situation, your family situation. All right. There are many ways to create this box or bowl that we've been talking about as a trust. Regardless of whether we're talking about a supplemental or special needs trust, you can do that either as a document that takes effect, that exists during your life, or you can do it as a document that only begins to exist at your death. If it's one that exists during your life, you can funnel assets into it if you choose to at any time. We call that a living trust, okay? If it doesn't truly come into existence until your death, that's a testamentary trust, and it's a trust that's inside your wills, okay? Last will and testament, that's where that word comes from. So it doesn't really exist until you have passed on, you're dancing with the angels, and once it's there, whatever the terms of your will state is what would actually flow into that trust on your beneficiary's behalf. Either way, whether we're talking about the testamentary trust that doesn't come into existence until after your death, or the living trust, which allows you to contribute to it during life, either way, your loved one's assets are or eligibility for benefits is protected, both for SSI, for RSDI, for railroad retirement, for VA, for Medicaid, for all purposes we can, with proper construction, protect that eligibility. Definitely for supplemental needs trusts, also primarily for special needs trusts, and I promise you I will define the difference between those two very, very soon. The goal is to pay for things that the government benefits programs do not pay for, whether we're talking about waiver services, whether we're talking about medical care, whether we're talking about housing, whatever it might be. You want your resources or your loved one's resources to stretch as far as they can to improve the quality of life, give the best quality of life that's possible given whatever resources there might be that flow into that trust document. If you do a living trust, special needs trust, supplemental needs trust, and you fund it during your lifetime, that trust will have income tax potential. If it's a revocable living trust, you would include the information, the earnings on it, the expenses on it, on your own 1040 if it's a third-party trust. If it's funded with the assets of the individual, of the disabled individual, it must be an irrevocable trust in order to protect eligibility for benefits, and it would file a 1041, okay? if you do a living trust with your assets, and it is irrevocable, and I'll tell you why that is a good idea sometimes, most of the time, it will also file a 1041 rather than a 1040. When we're looking at trusts, sometimes you want other people besides yourselves to be able to contribute. If you have a revocable trust, from IRS's standpoint, that's not a completed gift. It makes it very difficult, if not impossible, for grandparents to contribute, for example, to a trust that you've created. It creates IRS problems for everybody. So if you want there to be even a possibility for anyone other than yourself to contribute to a trust for your loved one, then you would do it as an irrevocable trust. And if you fund it during your lifetimes, which you are actually not required to do beyond a nominal $10, then you would make it an irrevocable trust and file a 1041. Okay? I know this is way more than you will remember down the road, but don't worry about that. All right. I've said that we want to maximize quality of life while stretching out benefits. So when we're looking at an individual situation, we look at what does that family have for the individual who has the special needs. Is that person eligible for any form of Social Security, Medicaid coverage, Medicare coverage? Some people have both Medicaid and Medicare. If the person receives waiver services, they may have room and board through supports for community living or assistance with it. They could have Section 8 housing for reduced housing costs, basic personal needs, care supervision, employment services, and medical care. Those all may be covered through, or primarily covered, maybe not entirely covered, through those government disability programs. On the other hand, there's lots that's not covered. And on the right side of this slide that you're looking at, trust, for example, could typically assist with medical, dental care that's not covered from any of the social benefits. If the person has Medicare only, they'll give you a cleaning, but they won't fix any teeth. And Medicaid, currently, they'll give you cleanings, but again, they won't cover caps or dentures or any of the things that some of your loved ones will need. They don't cover adaptive equipment. They don't cover technology expenses, vacations, trips. And if we have cutbacks in programs, you may need to be able to also cover basic care and expenses, personal hygiene, grooming. You know, SSI beneficiaries who either are long-term care residents in nursing homes or who are adults with waiver services, remember that those are substitutes for long-term care in an institution. Do you know what their monthly spending limit is and has been since 1973? $40 per month. That they don't care how it's spent. You could do a whole lot more with $40 per month in 1973 than you can do now. That has never had a cost of living adjustment or even a one-time adjustment since 1973. It's insane, but that's why that $40 a month isn't going very far. That those SSI recipients are now allowed. All right, now we're going to get to the differences between third-party supplemental needs trusts and, as you'll see on the next slide, first-party special needs trusts. A third-party trust or a supplemental trust is what people other than the person with the disability can do, family members, friends, in order to provide something extra for their loved one with a disability. And it can be anyone in the world. For example, I could contribute to a trust that Tammy sets up for her child. Not a problem. Doesn't matter who contributes to it as long as it's properly drafted. You cannot put the assets of the person with the disability into this trust. It must be assets belonging to someone else. And that's really why we call it a third party or supplemental needs trust, okay? So that's a huge, huge difference. And really, this is still the same as of 2016. Medicaid has no ability to put a lien or any kind of claim against the balance that might be left when an individual who is the beneficiary passes on. They cannot do Medicaid recovery from this trust unless you've polluted it, which I've seen more than once, with contributions from income and resources of the person with the disability. You cannot do that. It has to be only the assets of someone other than the person with the disability. You as grantor or settlor, or trustor, those are all synonyms for the same thing. So if you're working with an attorney who calls it a settlor or a trustor, just know it's the same thing as what this slide I'm calling a grantor. Person who sets up the trust has the ability to say what happens with whatever's left. Now, every once in a while, I have somebody say to me, I don't care, Medicaid has paid many thousands of dollars, hundreds of thousands of dollars sometimes for my loved one. I don't care if Medicaid recovers. And then I'll say, do you have other children that you would want to protect? And oh, yeah. You can leave it for your other children. You don't have to let it go back to Medicaid as long as you have not polluted it and it's a properly drafted trust in the first place. Whenever we're talking about a supplemental needs trust, this is what I'm talking about, an asset or a trust that is funded with assets of someone other than the person with the disability. There are many, many, many attorneys who call all of these trusts special needs trusts. It's important, even if the attorney is using the same word for both things, it's important for you to understand that they are not all the same. Okay, you may know more than your attorney. If you just remember that. And in fact, if I draft a special needs trust, or if I draft a trust that has in the title of it the Emily Special Needs Trust, Irrevocable Special Needs Trust, and it doesn't have Medicaid recovery provisions in it, Tracy would get a letter back from Medicaid saying, this is not a special needs trust, this is a third-party trust, even though it doesn't satisfy the requirements of a special needs trust, we will not count it as a resource. So I personally never, ever, ever use the word special needs trust because in the regulations, that only exists for the resources, assets of the person with a disability, okay? So you keep that in mind, that no matter what your attorney does, make sure that it is the right kind of trust for your situation, that it can only contain your assets, and if it's intended to contain the assets of your loved one with a disability, for example, because of an accidental inheritance or a Social Security payback document or some of the other things that we talked about earlier, then it's a first-party trust. And sometimes these are called special needs trusts. Sometimes they're called D4A trusts. Sometimes they're called just first-party trusts. they're all synonyms for the same thing. The D4A, if you ever see that, that comes from the tiny little subsection that's all of about 3 lines long in the Social Security Act. It's at, you don't need to write this down. It's at 42 USC 1396P D4A.
I'm impressed.
I've been doing it for 20-something years. You don't need to be impressed. If I didn't know it by now, I should just retire. So the D4A that's telling the reader, and it's telling Social Security without looking further. We're talking about a first-party trust, a trust that's to be funded with the assets of the person with the disability. Okay? Because it's funded with the assets of the person with the disability, and because Medicaid may have been paying for medical expenses for that person over a very long period of time by the time that person passes on, Medicaid is required by federal law to attempt to recover from whatever is left in that trust at death. As a practical matter, if there is less than $10,000 in it under the current rules, Medicaid will not recover that. $10,000 is exempt. But anything more than $10,000 that's left will be recoverable. There are also specific requirements here about who can even establish this type of trust. Under the current rules, this type of trust must be established by a parent, grandparent, legal guardian, or court. Who's missing from this picture? The person. A person who might, for example, have physical disabilities but is mentally competent. A person who might have some limitations but still knows what they're doing and can make basic decisions for themselves. That's what a pending statute, the Special Needs Disability Fairness Act, is about. Have you heard of that? Okay. And I really hesitate to tell you this story in an election year, but way back when the most recent, which was now almost 17 years ago, I may have my years wrong, when Hillary Clinton was serving as senator, she was on the committee that was doing the revisions that gave us our current rules for first-party trusts. And as it was told at the time, and I don't have first-hand knowledge, I was not in the room when they were doing this, but as it was told at the time, it was 3 or 4 in the morning and they were trying to put the final pieces together, and nobody noticed that competent adult with disabilities was missing from the list. And she said, we have to get it done. It has to go to press. Stop. I have no idea whether that's actually the way that it happened. I just know that's the way it came out of committee, that was the story being told at the time. Take it for however you want to. I don't know. But regardless of how it happened, the person with the disability was omitted. And so we have a proposed legislation that's pending now that is intended to try to fix that so that a person who is competent doesn't have to say, Mommy, Daddy, could you do this for me? Or doesn't have to go to court if there's no surviving parent or grandparent, and if there's no need for a legal guardian. I can't tell you how many times I've had to go to court for a competent adult saying, Your Honor, we're just trying to get permission to do what the person should be able to do for themselves, but for this federal statute that forgot about them. So hopefully soon we won't have to do that anymore. But for at least right now, if we're talking about a trust to be funded with the person's own assets, it's parent, grandparent, legal guardian, or court. Unless you happen to be doing a pooled trust. And we haven't talked about a pooled trust at all. I told you that this type of trust is also sometimes referred to as a D4A trust. A pooled trust is a D4C trust. From that same little section, just a few lines down, a pooled trust. A pooled trust is for most purposes, a first-party special needs trust in many cases that must be operated, managed by a nonprofit organization set up for that purpose. And you know what? In the regulations that applied, and the portion of the statute that applies to first-party trusts going through pooled trust, the individual can do it themselves if they're competent. They don't have to go through parent, grandparent, legal guardian, or court. They needed a few more minutes for editing that statute, I think. Because it is first-party money, once again, Medicaid has a right to recover. Whenever you're thinking about the two types of trust, third party, first party, self-settled, D4A, whatever you want to call that first party, it's important to remember the differences. Third party is always funded by the assets of someone other than the person with a disability. First party should only be funded with the assets of the person with a disability. Third party, anyone can establish for anyone, anywhere in the world. First party, under the current rules, has to be established by parent, grandparent, legal guardian, or court, unless they're establishing it through that nonprofit organization. Medicaid has no claim against anything that might be left in the third party trust, unlike first party, where Medicaid can claim everything in the current rules over $10,000. Third party, you as grantors or settlors decide who gets the remainder. In most cases, with the first party, there won't be anything left for remainders. You should still name possible remainders just in case, but in all practicality, there's almost never something left for remainders once Medicaid has taken its cut, or there's very little left when Medicaid has made its claims. There's another difference as well, and that is the first party trust can, first party trust in general, especially if it's a private trust, cannot be funded over the age of 65. Once that person has his or her 65th birthday, no additional contributions can be made to that trust unless under the current rules in Kentucky. And I'll explain why that's an important distinction. If it's in a pooled trust, under the current method of operation, Medicaid will allow contributions of beyond age 65 to the pooled special needs trust. Because the pooled special needs trust will pay Medicaid back, in general, most states, Florida also is currently treating it the way Kentucky does. But for most states, if someone with a disability makes a contribution of their own assets into a first-party special needs trust and it's not in a pooled trust, Medicaid treats it as a transfer for less than fair market value and penalizes the person for a period of months up to 180 days for the amount of care that that transfer over age 65 would have paid for, okay? Right now, and I can't guarantee that it won't change next week or next month or next year, but right now, Kentucky is one of the few states that's allowing people still to transfer funds beyond age 65 into a pooled trust and not disqualifying them from benefits. I know that Florida is also doing that, and there are a few other states that are, but most of the states are saying, whoa, we better not allow this even with a pooled trust. Okay. Pooled trusts. We've talked about this very briefly, but just to summarize and to give you a distinction, I've said as we've been talking that I want you to think about a trust as being a bucket or a box or a cup or a bowl or however you want to think of it, a vehicle to receive assets. As a practical matter, you could think of that as a checking account, a savings account, a certificate of deposit, a piece of real estate, whatever makes sense in your circumstances. You can have those things that you are the trustees of during your lifetime, and it's what we call a private supplemental needs trust or a private special needs trust. When we're talking about a pooled trust, as I said, from Section D4C, must be operated by nonprofit organizations that are tax exempt. Every single state in the country has at least one pooled trust serving its residents. There can be multiple pooled trust accounts. That's not a problem at all. And most of the pooled trusts have both first and third party options. And some of them allow you to maintain a separate trust through the nonprofit organization rather than pooling your money. And some of them require that the money be pooled. And when I'm saying pooled, P-O-O-L-E-D, it's pooled for investment purposes so that people can have small amounts of money but when it's pooled together with the assets of other individuals, you can take advantage of different kinds of investment opportunities than would be available to you if you were only contributing $50 a month or whatever it might be. But for accounting purposes, it is completely separate and fully vested. And for a lot of people, it's easiest to think about it as what happens with your IRA or 401k, that you might have a little bit going in that's yours, but it all goes into this mutual fund or that stock fund or whatever for investing, but for accounting, it's fully vested in you. And Susie Q can't touch yours or your loved ones, and your loved one can't touch anything that belongs to Susie Q. So that's how those work. And all pooled trusts, even though they're nonprofit, they do have fees. They still have to pay their employees and rents and utilities and reporting expenses for SSI and Medicaid and Social Security and the IRS. So there are some expenses, and that's something that if you're considering a pooled trust, you should always look at. I don't know why Midwest came up first there. All right, pooled trusts that are currently serving Kentucky. Life Plan of Kentucky is the only one that's actually physically housed in Kentucky. We serve Kentucky residents only, but if it's, we have a lot of states on our border, and people move back and forth across state lines pretty regularly, so it's not at all uncommon, for example, for Life Plan to have a client move from Ohio to Kentucky and even back again. And what we do is we just help the client transfer funds that are in their account from life plans pool trust directly to the Ohio Pool Trust or back again. We actually have one client that I can think of who has moved back and forth across the state lines in the Cincinnati area 3 times so far. 3 times he's been a client of Life Plan and in between Ohio because he's right on that border and has done some pretty frequent moving. The Midwest Special Needs Trust, if you've looked online at all, you may find references to the Midwest Family Trust. That's the same trust, but it is, they changed their name a few years ago. So it is the Midwest Special Needs Trust now. They actually serve 7 states. Their home is in Missouri, but they do serve Kentucky residents. The National Foundation for Special Needs Integrity, they are located in Carmel, Indiana. They also serve Kentucky residents, and they attempt to serve all 50 states. And the final one that I'll mention to you is the Center for Special Needs Trust Administration in Florida. And it is also a national pool trust. And I've told you that I serve as executive director for Life Plan, so I'll tell you that I'm biased. But I also advise people against my best interest to use a pooled trust when it makes sense in their circumstances to do so. And because I earn less money as a private attorney if I'm not drafting a private trust for you, but I still will tell you, please take this into account. With an organization, you don't have to worry about if a person dies. You don't have to worry about, will this person make appropriate decisions keeping up with Medicaid rules, SSI rules, IRS rules. That's the job of the organization. And in order to qualify, and this applies to all pooled trusts, not just Life Plan. But if the organization qualifies as a 501c3 organization, they have to have a continuation plan in effect so that if something happened to the organization, there's a successor plan. They can't just close the doors and go out of business and all the money disappears. There has to be that, or the IRS will not approve the 501c3 application. Distribution requests are reviewed to make sure that whatever is asked for will not jeopardize the beneficiary's eligibility for benefits. Accounts can be opened up very quickly. They're definitely less expensive to establish. Unfortunately, when you were doing yours, we didn't even have this yet. And they typically will accept smaller amounts to open and maintain than if you went through a corporate trustee. And quite frankly, it's through a for-profit corporate trustee. Quite frankly, it's getting more and more difficult to even establish any kind of special needs trust or supplemental needs trust through a for-profit corporate trustee. Chase Bank, for example, has removed all of its trust departments from every branch in Kentucky, and in order to do either a supplemental needs trust or special needs trust, they're currently requiring, I believe it's $5 million to open it, and most people aren't funding their trusts with $5 million. Other financial institutions, if you want them, if you're actually going through the trust department, it'd be a minimum of $500,000. And the truth is that the financial institutions are looking more and more for ways to work with pooled trust organizations because they are good at managing money. They don't want to be responsible for making a mistake that causes someone to lose eligibility for benefits. So they aren't real comfortable. The more complicated things get for you, they're worse for the financial institutions because they have a much higher expectation of responsibility for making mistakes or not making mistakes. So they don't really want to deal with these types of trusts. So as a practical matter, for most people, your choices are a private special needs or private supplemental needs trust that you serve as trustee of, you manage the money, or the pooled trust that the organization serves as trustee, and the individual, if competent, can make distribution requests. Anyone with power of attorney, whether it's parent, other relative, friend, could make distribution requests on behalf of that person. As a practical matter, that's becoming really your potential means of establishing these. These websites will all provide helpful information about trusts themselves. So you'll find, for example, KentuckyHope.org, they have great information. Special Needs Trust Center, that whole list. They're good sources of information. And will they have access to these slides after, so you don't have to try to write it all down?
No, we can, again, we're going to put this up on our website, and Karen, if it's okay with you, I can email everyone the PowerPoint also. That's fine.
No problem at all, because I'd rather that they just be able to relax and pay attention.
Yeah, that's fine.
Okay. So moving into ABLE, I had to spend quite a bit of time giving you that basis in first-party and third-party special needs and supplemental needs trusts, so that you would be able to, I hope, more easily understand what ABLE is all about. ABLE is an acronym that stands for Achieving a Better Life Experience. It was passed in 2014. It's part of a much bigger piece of legislation that was intended to try to prevent increases in taxes. I'm not sure that really worked, but uh-oh, I skipped a slide. There we go. And its goal, the subsection of the statute that is ABLE, its purpose was to provide an additional safe harbor for the financial assets of the person with a disability. Notice I said of the person with a disability, not you, okay? It will also provide protection from income taxes. It's a tax-favored document. So, for example, if someone opens an ABLE account and makes a contribution to it, the earnings on that will not be taxed, as long as the expenses from it are qualified disability expenses. And when we start looking at the handouts in just a minute, we will actually talk more about what each of these things means in detail. It's also going to protect eligibility for needs-based benefits and expands the protection beyond what first-party trusts protect for such things as food stamps, Section 8 housing, subsidized housing, and anything else that is needs-based. The rules are much broader in terms of what's okay, and SSI is currently having to revise its regulations to comply with this in many areas. It also has protection from creditors, just like the first-party trusts. First-party trusts are required to have spendthrift language in them, but it expands in ABLE the protection from creditors, including complete protection in bankruptcy. And it also reduces the impact of Medicaid recovery sometimes. For example, if a person has been receiving supports for community living waiver and has a first-party special needs trust, any assets at death in that first-party special needs trust is recoverable all the way back to when the person was born. funds that are left in an ABLE account when the person dies are only recoverable for medical expenses following establishment of the account. So that, in some circumstances, can substantially shorten and minimize the amount recoverable. Now, we need to actually look at the handouts, and I'm going to escape from that. Well, maybe I am, and go to this one, and go to the top.
And if you want, I'll pass these out.
So, this chart was actually developed by Carolyn Wheeler, who is longtime friend and colleague, and she was trying to get a handle on what are the differences that she could understand. And so she ran it by me, and we tweaked it some. This is a really good summary of that Carolyn needs the credit for, not me, of the differences between the ABLE account, first party special needs trust, and third party supplemental needs trust. And I'm going to walk us through it and add some things to it as we're going through. First, in terms of what is an excluded resource. In the ABLE account,
This is one we're looking at now.
yeah, you're looking at that.
Are they all? Okay, good. They're stapled together. I didn't see it.
Okay. All right. So money in the ABLE account, even if a person is receiving SSI, is excluded up to $100,000. So a person who on SSI, if they just had cash in their hands in their own names, if it's over $2,000, you know they lose it, lose eligibility, right? And if they have Medicaid, you know they lose eligibility with more than $2,000 under traditional Medicaid. With an ABLE account, there can be up to $100,000, and even then, with SSI, they are not losing eligibility. What happens is the amounts, whenever there are amounts above $100,000 in there, the SSI monthly income payments are suspended until it falls again below the $100,000 limit, but the eligibility is kept. So you don't have to go through the whole reapplication process just because somebody temporarily had too much in that account. And for Medicaid purposes, we even have a bigger number. For Medicaid purposes, under the current rules, it's exempt up to $350,000, or not countable under up to $350,000. So you could have, let's say someone gets a big financial cash settlement from a personal injury lawsuit or something. You could have a big chunk of money. Person might have been receiving SSI. If it's over $100,000 but less than the current $350,000, they're going to keep Medicaid because they're still under $350,000, and they're going to have their SSI payments suspended but not lose their eligibility. They will, whenever that account falls again below $100,000, they will immediately be eligible to have the SSI resume for monthly income payments. That gives a whole lot of flexibility that was not there before. Now, by contrast, first-party special needs trust, it doesn't matter how much is in there. As long as it was properly implemented, properly drafted and properly implemented, there's no upper limit. So that is more restrictive in some ways, but I think you'll see that for a lot of people, there could be really good reasons to do an ABLE account rather than a first-party trust in particular. And the same is also true for the third-party supplemental needs trust. Any amount of resources is excluded, again, as long as it's properly implemented, properly drafted. age of person with a disability in order to be eligible to open that account. The person's disability has to have occurred or existed before the age of 26, compared to before the age of 65 for a first-party special needs trust. And with a third party, there's no age limit whatsoever because the assets don't actually belong to the person with a disability. Okay, they belong to you or someone else for your loved one, but they don't belong to that individual. In order to qualify for the first party special needs trust, the person has to meet the pretty stringent disability procedure rules under the Social Security Administration. For example, they have to qualify financially, they have to qualify medically. There's basically a 5-step process that you have to go through. Initially, with ABLE accounts, it was anticipated that those would work the same way, but as a practical matter and by subsequent regulations, it really has broadened up and opened up significantly so that under the current system, a parent or guardian can certify by affidavit that the person was disabled, did have severe and significant condition that impacted major life activities. There's language that needs to be used in the affidavit. But as long as you meet that and you're not lying and committing fraud, which is a criminal offense, by the way, so you don't want that. Even if the person doesn't have a Social Security Administration determination of disability prior to age 26, they can still be eligible to open an ABLE account. Okay. How much money may be contributed annually? There are no limits for a first-party trust and no limits for a third-party trust, unlike the ABLE account. With ABLE, there's a $14,000 per year, which comes to $1,166 limit per month for an ABLE account. And why did that happen? Because when figuring out the tax advantages of doing it, remember this was part of a statute that was intended to prevent tax increases, Congress decided that we will put this in Section 529A, which is close to 529 for educational plans for people. And what is the yearly, and remember, it's the IRS putting these regulations together, not anyone who knows anything. I mean, seriously, they didn't think about, okay, this is the person's own money. So they said, well, we're just going to use the gift tax exemption amounts. The person's not making a gift to themselves. Why would you use that amount? No good rational reason. It's just, well, we're thinking about, we're putting it in 529A. It's close to 529s. We'll use the federal gift tax exemption amount. So don't be confused by that. It doesn't mean that you should, as parents, be contributing this for your loved one. But it does mean if you're in a situation where you are required to pay child support, for example, to a child with a disability, you may want to go get a court order giving you permission to pay it into the ABLE account, because it opens up and gives more flexibility for how that money is used, as long as your child support monthly is not more than $1,166. And, you know, that's an extra tool that gives more flexibility. Or even if you have a disabled ex-spouse, mean, I know most of you are here for your children, but if you've got a spouse who's disabled and you're paying alimony, the same thing applies, that the person would have more flexibility about how to use the funds if you can pay it right into the ABLE account instead of into a special needs trust of either kind. Tax treatment, we've talked about this very briefly. Let me just roll down. Tax treatment, the interest on whatever's in here can grow tax-free as long as distributions are only made for qualified disability expenses. This is different from what happens with the first-party trust, which, as I told you at the very beginning, has to be an irrevocable trust, and therefore it has, if there are earnings on it that make it subject to income tax, it has to file a Form 1041. Unlike a Form 1040 where you're filing income taxes based on your own personal exemptions, do any of you remember what, because I'll confess, I haven't yet filed my taxes for 2015. What's this year's personal exemption amount? Like $3,750? I think it's $3,750 or $3,800. It's in that neighborhood. If you have to file a 1041, the trust's exemption amount is only $600, and the tax rates increase very quickly. So if you happen to have a large trust that has to file a Form 1041, when you get to $12,400 per year in earnings, which may not apply to most of you, but still, when you are at that point, you are at the maximum income tax rate, which right now would be 39.6 or 39.8%, 39.6% plus a Medicare surtax of 3.8%. So you're almost half of everything that you earned would be taxed. So that's a potential advantage for the disabled individual who has assets of his or her own to be able to use the ABLE account, because it'll grow tax-free as long as they remember that it has to be spent on qualified disability expenses only. So what are qualified disability expenses? Qualified disability expenses includes education, transportation, housing, food, and that's a big plus for individuals who are SSI recipients, adult SSI recipients. They are not supposed to use first-party trust money for food and shelter, okay? It doesn't affect third-party trusts as much, but first-party trusts, this is a really important distinction between the ABLE and current rules for first-party. You can use ABLE accounts for food and shelter. It's very limited with SSI and first-party trusts. If you spend money for food or shelter out of a first-party trust, it will reduce the person's SSI benefit by 1/3. There will be no impact on the person's SSI benefit if it comes out of the ABLE account. Okay, they will not lose anything. So these are things that Social Security Administration is dealing with now and trying to figure out how are they going to handle this. And part of it is because, part of the reason they're being forced to deal with it is because the IRS defines a person who may contribute to a trust to include, to an ABLE account, to include a trust. So people who have first-party special needs trusts are finding ways to contribute amounts disperse amounts out of the trust into an ABLE account so that person can spend it for food and shelter that they couldn't have the month before ABLE came into existence. It's chances are. So hopefully it'll someday make more sense than it has made for many years, but we will see. Who can contribute? Anyone can contribute to an ABLE account. That doesn't mean anyone should. Because once you do, if you as a parent contribute to that ABLE account, first of all, you can't get it back if you need it. Secondly, it is subject to Medicaid recovery because the person owns what's in it. Once you've given it, it belongs to them. So if you're looking for estate planning purposes, please do it through a third-party supplemental needs trust so that you have say over what happens to the remainder. Okay? Let's see. Scroll down some more. I did something wrong. I was on the wrong scroll down. Sorry. Not that one. Yeah, that one. All right, let's get on the right scroll down. Just scroll down this way here. All right, who can access? This is a fantastic benefit of the ABLE account. The person with the disability, if competent, or the person's power of attorney, or the person's guardian can access the funds in the ABLE account without going through and asking the trustee for permission to use money that might have been in that first party special needs trust account. It gives so much more potential for independence and autonomy than the first party trust option does. That can be hugely helpful to anyone that's a competent or mostly competent adult, okay, to just say, I want to go to the movie, I want to rent this apartment, to buy this vehicle, assuming they're a licensed driver, to just not have to say, can I do this, can I do that, to be able to do it. I mean, sometimes that's not realistic or reasonable, but when it is, this does provide a good option for people who have money in their own names and need to protect eligibility. Who's responsible for documenting that the expenses are only used for qualified disability expenses? When we're talking about the two trust options, the trustee is always the person responsible person or entity. When we're talking about the ABLE account, then we're talking about the person with a disability or that person's legal representative, which could be a family member that they've designated. It could be someone with power of attorney. It could be a legal guardian or conservator, whatever the situation may be. And for Medicaid recovery, we've talked about this. The money in this trust, in this account, just like the money in the first party trust, it belongs to the person with a disability. So there will be Medicaid recovery at the death of the person. With the third party trust, there will not be Medicaid recovery because it does not belong to the person with a disability. And sometimes people have both first party and third party trust accounts. If that's the case, or if they have a first party, an ABLE, and a third party supplemental needs trust account, which ones are you going to spend first? The first party. Anything that belongs to the person with the disability, you spend that first, okay? Or that client spends that first. Because everything is potentially subject to Medicaid recovery. If you want to have any say, or your loved one wants to have any say over what happens with whatever might be left, preserve the third party for as long as possible, that supplemental needs trust. Keep that for as long as possible because you get to say what happens with that. First party, there's no choice. They're required to recover, okay? ABLE account, there's no choice. They're required to recover. Then I've given you, in the other handout that we have, and I know I've gone really fast through all this, even though you've been sitting here very patiently for a very long time. There are currently 4 states that have ABLE accounts set up. 3 of those, Ohio, Nebraska, and Tennessee, accept Kentucky residents. Kentucky passed legislation in April that allows people to establish an ABLE account in another state because we declined to establish the infrastructure necessary to set up and administer within Kentucky our own ABLE account. So right now, Kentucky residents are allowed to establish accounts in Ohio, Nebraska, or Tennessee. Florida's up and running, but they're not accepting out-of-state clients yet. Kentucky residents, as other states eventually open ABLE accounts to out-of-state residents, or as they get up and running, we don't have to have new legislation for Kentucky residents to be able to access the other states' ABLE systems, if it makes sense. The authorization is there. Whatever other state might make sense to a Kentucky resident in his or her circumstances will be fine. But I've given you these 3 with just basic information about funding minimums, the options, the fees. There are, for example, the Ohio account, which is called Stable. It has 5 different investment accounts, all of which have varying degree of risk, but one of which is what we call a capital conservation version. So you could deposit funds in a money market account or a savings account that's FDIC insured. You don't have to risk being in the market if you're not comfortable with that. Nebraska and Tennessee also have very many different options to choose from. Fees are different depending on which one you're looking at and whether you're an in-state resident or an out-of-state resident. I have no idea how they're going to handle clients like my guy who has moved back and forth between Ohio and Kentucky several times already. Maybe his fees keep changing if he is a Kentucky resident and opens an account in Ohio and then moves to Ohio and then moves back. I don't know how they're going to deal with things like that. There are no income tax deductions. It's not a gift or a charitable contribution for income tax purposes. But Nebraska does, for Nebraska residents, which doesn't help us, up to $10,000 for people who are married filing jointly. That's contributed to the account. And there I will stop and open up for questions.
And I'm going to quickly turn off the recording here. And then